Hi, everyone. Welcome. Thank you for joining us for today's webinar, When is Probate Needed and How Does it Work? We brought in our resident experts on probate, Abbey, Kaelberer, and Maria Henry, to break it all down, all the nitty gritty. My name is Beth Cohen-King, and I'm the marketing director at Margolis & Bloom. So the reason for this webinar is because we know that probate is hard, and the information is dense, but hopefully through watching this will explain the process with more clarity. We do have a panel on the side of the screen that you can use to type in questions as they come up. And I'm going to try to interrupt after each section that they discuss. And if questions come up, we'll try to get to them there. If we don't get to all of your questions, I'll send them along to Maria and Abby to follow up on. But please keep them as general as possible because we can't always answer very specific questions. And if for some reason you need to jump off, no worries. We are recording the presentation, usually available within a week after this recording. It will be on our website, and it will also be in the e-letter if you're subscribed to that. So with that, Abby, I'm going to let you take it away.
Thanks, Beth. Hello, everyone, and thank you for joining today. So the purpose of today's webinar is to provide a brief overview of what probate is, when it may be needed, and which type of probate that may be filed depending on the circumstances. The webinar will also give a brief overview of the probate timeline and process. So to begin, what is probate? Probate is the court process one may have to go through when someone dies in order to access and manage the assets and property of the person who died. They will also act on behalf of their estate, and the process may include transferring the ownership or retitling the assets and distributing them out to the beneficiaries of their estate. The probate process is governed by the Massachusetts Uniform Probate Code, which was adopted by the state in 2012. The process involves the court appointing a personal representative, who you may also know as the executor, who will be responsible for collecting property that is within the probate estate and distributing it out to the right people. The personal representative may also act on behalf of the estate to deal with any debts or taxes the person who died owed when they died or owe as a result of their death. Throughout this webinar, we will be referring to the person who died as the decedent. In most cases, the personal representative who was appointed had what is called a priority for appointment. The order for priority of appointment is determined by state law. The first people with priority for appointment are the person who's nominated to serve in the will, or an alternate person who's nominated to serve in the will. If that person cannot serve and there is a will, the surviving spouse who is a devisee of the decedent, or if there's no spouse, other devisees of the decedent. The term devisee refers to a beneficiary named in a will to receive or inherit property from the estate. So if there's a surviving spouse named in the will as the beneficiary, or someone else named in a will as the beneficiary, they are a devisee, and they also have priority for appointment to be appointed as personal representative. If there is no will, or no one named in the will can serve, the surviving spouse of the decedent, or if none, the heirs of the decedent have priority for appointment as personal representative. The heirs, also known as heirs at law, are persons determined by state law or statute to receive the inheritance from the estate. The last resort, if none of those people can be found or there aren't any, and there's no next of kin, a public administrator would be appointed as personal representative pursuant to state law. If a person dies and had a valid will, the person is considered to have died testate, and their assets will pass according to the terms of their will to the devisees named in the will. If the person died without a will, they are considered to have died intestate, and their property will be distributed to his or her heirs at law. So next we will review what is probate property and what property will not be part of the probate property. So not all assets owned by a decedent when they die are probate property. And by assets, we're referring to real estate, bank accounts, stocks, etc. So jointly held assets, assets held in trust, or accounts that had a beneficiary named on them are likely to avoid the probate process. For example, in Massachusetts, it's common for married couples to own real estate as tenants by the entirety. This means when the first spouse passes away, the property will pass without probate to the surviving spouse. A decedent could also own real estate as joint tenants with rights of survivorship with another person, and their interest would pass to the other owner who survives them without probate. Jointly held bank accounts will pass to the other owner without probate, but note that a power of attorney account or a custodial account, such as a 529, these are not the same as a jointly held bank account. So an account with two owners will pass without probate. Those other types of accounts may not pass, those may have to go into probate. Similarly, many people name beneficiaries on their annuities, retirement policies, and life insurance policies, and these will pass without probate if a beneficiary is named and living when the owner of the account dies. This also applies to bank accounts where a transfer on death designation was made for the account to pass to someone when the owner dies. That will also avoid probate. Consider that in all these examples, the other joint owner or the beneficiary must still be alive and have survived the decedent in order to avoid probate. If there's no joint owner or beneficiary named, the default beneficiary is the estate, and so the asset will pass through probate either under the will or, if there's no will, to the heirs at law. So now that we have briefly covered what non-probate property is, we'll discuss what is considered probate property and what might cause a probate. The most common reason there is a need for probate is because there was an asset in the decedent's name alone that has no beneficiary designated. It's important to note that just because someone had a valid will, it doesn't necessarily mean they're going to avoid probate. So here are some examples of assets that may cause a probate because of the way they were held when the person died. Any real estate, like buildings or land, held in the decedent's name alone, or they were held by the decedent as with someone else as tenants in common. Bank accounts, investment accounts, or brokerage accounts held by only the decedent with no beneficiary and no joint owner. Annuities, life insurance policies, and retirement accounts where there was no beneficiary named or where the beneficiary was deceased. Stocks or business in interest in business, such as an interest in an LLC held in the decedent's name with no beneficiary, would have to go through probate. Additionally, savings bonds that are held by a person in their name alone with no beneficiary or who had a beneficiary that was deceased would have to go through probate. And motor vehicles if only the decedent's name is on the card. The exception to this rule is if there is a surviving spouse to the decedent, the vehicle can be transferred outside of the probate process through the Registry of Motor Vehicles. Additionally, some items of tangible personal property, like valuable family heirlooms or jewelry, could be involved in the probate process. There are additional reasons that may arise where there is a need for a probate proceeding that does not necessarily have to do with just the way the assets were titled. For example, the appointment of a personal representative is necessary because someone needs legal authority to act on behalf of the estate. This could arise because a personal representative needs to deal with the creditors, debts, or taxes of the decedent. A personal representative may be needed to deal with a situation involving real estate of the decedent. There may be an unrelated court proceeding or a lawsuit that involved the decedent that is still ongoing. Another reason to initiate a probate proceeding is if one needs to determine who the heirs at law are. So this situation arises where there are heirs to the estate that are unknown. This might occur when someone has died without a surviving spouse or surviving children, and there's uncertainty as to who the next beneficiaries in line are. You would need to file a probate to determine the heirs at law. One final reason to a probate proceeding might be needed is to determine whether the will is valid. So now that we have discussed why a probate may be needed, Maria is going to discuss the different types of probate and when one might be filed versus the other.
I'm just going to jump in. We do have a few questions that have come up, so we'll go through those before you start, Maria, if that works. So one of the questions, how much legal exposure does an executor have in selling the estate?
Well, the executor, personal representative, has a fiduciary duty to distribute, properly distribute the estate, pay off the creditors, and so they're held to a fiduciary standard.
Okay. And so if you own real estate, and I'm just going to say what this is because not everybody might know this, is a joint tenancy with survivorship. So that's the JTWROS. And your assets are in a revocable trust. Can you avoid probate altogether?
So can you repeat that question?
So if you own real estate with the joint tenancy with survivorship, are your assets are in a revocable trust, can you avoid probate?
Yes, based on that. Yeah, so the joint tenants with rights of survivorship would avoid probate upon the passing of the first owner. It would pass to the other owner, and then the assets that are in the revocable trust would avoid probate as well.
Okay, and then you said this, but just to repeat it, can you repeat how 529s transfer after death?
I think the point with that was that asset doesn't avoid probate. So if the account owner died who held it for the benefit of someone else, that might end up in probate, was the context of when we discussed that.
Okay. And then one more, and then we'll jump into Maria's. If you have I can't read that. All right, well, we're gonna skip that one. Maybe I can't read all of that. If all property is distributed via beneficiary designations, does the personal representative still have to file for probate to file final tax return only?
So if is the question if the only reason they need to file probate is to file for in order to file the estate tax return?
I think so.
The final taxes. The final income taxes?
Yeah, I think so.
Yeah.
Yes?
Are you, if it's only to file the final income taxes, no.
Okay. All right, let's stop there. And Maria, why don't you take over and we'll keep going, okay? Thank you.
Hi, everyone. Okay, there are 4 types of probate: voluntary administration, informal probate, formal probate, and late and limited probate. Voluntary administration can be used. It's a simplified process when an estate is comprised of real property with a combined value of less than $25,000, and that's excluding one motor vehicle, the value of one motor vehicle. The estate will be distributed according to the decedent's will or Massachusetts law if there's no will. The petitioner, who is the person requesting the appointment, must be an interested party as defined by Massachusetts law and the statement cannot be filed until 30 days has passed from the decedent's death. The petitioner does not need an official appointment by the court like the other types of probate. He or she will receive what's called a statement of voluntary administration allowed, and only gains control over the assets listed in the petition for administration. And again, the assets have to be under $25,000. This is often used when a personal representative believes that there are no probate assets, but later on may discover savings bonds, an old life insurance policy, stock certificates, where the decedent was either the sole owner or the beneficiary. There may also be dividend checks and other uncashed checks. In some cases, family discovers that there's abandoned property listed on the Commonwealth's website. If these assets total under $25,000, a simple probate would be the voluntary administration. If more assets are located later, the petitioner would have to file another voluntary administration because the specific assets have to be listed on the petition. Number 2, informal probate. On occasions when administration of the estate is expected to be routine, all persons appear to be in agreement, the quicker informal procedure may be appropriate. This process can be used if the decedent died testate with the will or intestate without a will. The informal procedure enables quicker opening of the estate, but will not result in a judicial decree. Informal probate does not result in judicial determination of testacy and also determine the heirs. Informal probate occurs without the presence of a judge. There are no hearings, and the process can be expedited if the estate and the will isn't in violation of any laws and nobody objects. Informal probate is not available if you cannot locate the original will, if you don't have an official death certificate, if the location and identity of heirs and devisees aren't known, if a judge must sign an order of final decree, if there's a spouse, heir, or devotee that's incapacitated or a minor, not represented by a conservator or a guardian, and if the person to be appointed personal rep does not have priority of appointment. And finally, an original will has interlineations or deletions. A personal representative may be appointed by the court or magistrate as soon as 7 days after the death, although it often takes longer depending how the court's running. The personal rep has full powers equal to a personal rep appointed under formal probate. The informal probate of a will may be contested at any time up until 3 years after the date of death. The remedy for a person aggrieved by an informal probate is to file a petition for formal probate within that time. If it can be anticipated that there may be contentious issues to be resolved during the administration of the estate, a formal proceeding to open the estate may provide the best protection to the fiduciary, and the matter may be commenced by a formal probate. The formal probate is the most common probate used. A formal probate provides appointment of a personal representative, and they're formally known as executors or administrators, and or allowance of a will by order and decree of the court after notice and opportunity for hearing. In a formal proceeding, the court officially determines the decedent's domicile at death, the heirs of the estate, and the status of testacy, whether or not they left a valid will or died intestate. A formal probate typically occurs in the presence of a judge and may take place over the course of 1 or 2 hearings, although in many circumstances there's no court appearances necessary. Some of the reasons you must file a formal probate: the terms of the will weren't clear, an interested party objects to the will, or the appointment of the personal rep. There are incapacitated or minor heirs or devisees, or to appoint the personal rep who does not have priority. If the estate includes real estate, more particularly registered land, or if the petitioner seeks protection of a final judicial decree. Other reasons include if the petitioner is a creditor, guardian, or public administrator, or to order supervised administration, or to appoint a special personal representative, or a creditor or public administrator are the petitioner. An example of why you may prefer to file formal: if the estate consists of probate assets, including real estate, it may be advisable to file a formal probate. If you're selling the real estate, there could be title issues that would arise because the determination of heirs has not taken place in an informal probate. Or if you're keeping the real estate and the heirs and devisees want to keep it in their names, you may want to file a formal probate to determine those heirs. Another example of why a formal probate is advisable is if you know heirs or beneficiaries that don't get along. They have a problem with the will. They may have a problem with the personal representative. The personal representative may feel better knowing that the court is overseeing the probate and that he or she will ultimately be discharged of his or her duties by the court. If you filed an informal probate at any time, it can be transferred. You can open up a formal probate and discharge it formally. The last form of probate is called a late and limited formal probate. If no probate was filed within 3 years from the date of death of the decedent, you would file a late and limited probate if the decedent died on or after March 31st, 2012. There's been no estate proceedings that's happened within the 3 years, and you only need formal testacy or appointment proceedings to confirm ownership of probate assets. This process is often used when it is discovered that the decedent had an ownership interest in real estate and the real estate is being sold or transferred. The court may accept a petition to admit the individual's will to a formal probate or verify that no other will exists or to determine heirs. The court can then appoint the personal representative to administer the estate. And the personal representative in this probate can only confirm title to estate assets and cannot sell real estate of the decedent.
Beth, do we have any additional questions before we go on?
Hi, yes. Are there any unexpected consequences of using bank TODs, and why are they uncommon?
Bank, what was that?
TODs.
TODs?
Yeah.
No, typically we do advise for small checking accounts or smaller bank accounts. If a TOD, a transfer on death designation, is made, that typically avoids probate as long as that person is living who is named as the transfer on death beneficiary designation.
Okay. And how is payment to where is this? Sorry, can't read that one. How is payment to the executor determined?
That's, sometimes people will put that in the will. They'll ask that the executor be paid. And then other times it's changes and varies in all cases. It depends on if they want to be paid, then we try to determine a reasonable amount. So it's very open-ended.
Okay. Great. I think that's where we're at now. We're caught up.
Okay, so now we will transition to giving a brief overview and sample timeline of the process once it has been determined that a probate is needed. So the first step will be securing the assets. So at this time, a personal representative will not have been appointed, but the would-be personal representative should secure the residence where the person lived and its contents, so that any distribution or disposal of assets happens in an orderly manner. One should also notify the financial institutions and credit bureaus of the death so that the assets can be frozen and preserved. The original will should then be located if possible, because that will be needed to file for the probate. And a death certificate should also be obtained, an original certified death certificate. the death certificate is typically given to the family by the funeral director. There will then be a determination of what is the probate assets versus what are not probate assets, what type of probate to file for, and then an estimation of the value of those probate assets. So as we discussed, whether you have an originally signed, notarized, and witnessed will versus just having a copy may influence which type of probate to file for. And if there's no will, it may affect which type of probate is filed for, depending on the circumstances. Similarly, the value of the probate assets will determine which type of probate is filed for. As we discussed, if the assets are under $25,000 because there weren't that many, a voluntary administration could be filed for. Then the necessary probate pleadings will be prepared for filing. Each of the different probates has specific filing requirements on what is needed in order to commence the action. And the notice period will also depend on what type of probate is filed for. A voluntary administration does not have a notice period or requirement to notify interested parties, whereas an informal probate, you must give notice to all interested parties 7 days prior to filing to petition the court for a probate. And once that is allowed, a notice must be published in the local newspaper within 30 days. For a formal probate and a late and limited probate, once the petition is filed to petition for probate, a citation is issued by the court, and after it gives a return date in the citation where the interested parties must be notified before the return date, and it must be published in a local newspaper before the return date. And then once the return date has passed, a certificate of service certifying all interested parties were noticed and that the citation was published will be filed. And once that certificate of service is accepted, the probate will be accepted and the will allowed. This process takes about 30 days or more. And now that we have gone over the filing, getting up to the filing process, Maria is going to discuss what happens once you have filed.
Next is the allowance of will and appointment of a personal representative. A personal representative will receive what is called letters of authority from the court when their appointment has been allowed. This will give them authority to act and to gain access to all probate assets. The personal representative will not receive this in a voluntary administration, as we previously discussed. They would just get a statement of that the voluntary has been allowed for the purpose of that one or two assets. Once the personal representative is appointed, they are responsible for gathering all the assets that are part of the probate estate and paying all the debts of the estate, including any taxes that may be due. They should also obtain a federal identification number from the Internal Revenue Service for the estate. They can open up a bank account at a bank or financial institution of their choosing. They'll begin to gather assets and deposit them into the account. Within 3 months after the appointment, the personal rep should prepare an inventory. The inventory will include all of the decedent's probate assets with a fair market value as of the date of death. The inventory should be provided to all interested parties, and in some cases will be filed with the court. During the next several months, all probate assets will be gathered and will be sold and transferred into the estate account. If the decedent has a taxable estate, which is determined by their probate and non-probate assets, an estate tax return will need to be filed within 9 months from the date of death by the personal representative. At the 1 year mark, creditors have 1 year to make and perfect a claim against the estate. If they have not made a claim by now, they are barred from filing a claim. So now the personal rep will begin preparing an accounting of estate assets, showing all income that's come in and all monies that's been paid out. They'll prepare the account and it will be sent to the heirs and devisees to review along with the release form. If all beneficiaries have signed the release form, then final distributions can be made. If some beneficiaries have not signed a release form, there is another avenue we could pursue, and that is to request a citation from the court. The citation would be sent to all interested parties with a return date. If by that return date, there's been no objections filed with the court, then it will be assumed that the account will be allowed. But in this case, you have to, if you've gone informal or formal, you would have to close it formally in order for the court to issue that citation. Closing statement versus petition for complete settlement. There are two ways to close the estate. A petition for order of complete settlement may be filed at court along with the inventory, accounting, releases, and decree of complete settlement. Once filed with the court and allowed by the court, the personal representative will receive a decree of complete settlement and will be discharged from his or her duties immediately. The petition for complete settlement may be necessary when a personal representative or other interested party wants protection of a formal decree allowing the personal representative's final count. A personal or corporate surety wants the protection of a formal decree to discharge the personal representative and have the surety from bond discharged. An informal proceeding was used to open the estate, and a formal determination of heirs at law or testacy is desired when closing the estate. Or a personal representative is serving in a supervised administration, is a public administrator, or otherwise court ordered to close under a formal proceeding. A closing statement is a simplified method to close an estate. Once filed, if no one files an action or objection at court, the personal representative will be discharged from his or her duties within 1 year of filing the statement. The closing statement may be filed whether an estate is being administered under informal or formal proceedings. The closing statement is a sworn statement by the personal representative, providing that he has determined the time limited for presentation of creditors' claims has expired, fully administered the decedent's estate by paying and settling all claims, expenses, and taxes of the estate, has distributed the decedent's assets in accordance with state law or their will, and has sent a copy of the closing statement to all interested parties of the estate, and has furnished an account to all beneficiaries of the estate. This will conclude our webinar, and we just wanted to let you know that it's best to consult with an attorney for your particular situation. Our firm provides estate administrative services, including probate, and can also prepare an estate plan that will minimize or avoid probate. Thank you.
All right, there are a few more questions. Backing up a little bit. Can a disgruntled beneficiary in a will contest how money was handled prior to death by the durable power of attorney? Can they request accounting of all accounts of prior to death, the decedent prior to death? Do you guys hear that?
Yeah, so can you just repeat the first part?
Can a disgruntled beneficiary in a will contest how money was handled prior to death by the durable power of attorney?
Okay, I believe that would have to be done outside of the probate. A beneficiary would have to make a claim against the power of attorney. Unless it was the personal representative that had the problem. Okay. They're representing the estate, but a beneficiary could make a claim against the attorney in fact.
Okay, thank you. Just to clarify, did you say that there being real estate in the estate always means that formal probate is required? You guys just...
No.
Okay.
No, it's suggested. You could do informal probate with real estate. However, if something comes up in the title, or if there's a question of who the actual heirs were, or anything like that, then you would have to transfer over to a formal. So sometimes might be better to go formal, but you don't have to. You can definitely go with informal, and if no problems arise, that's fine.
Okay. And does a power of attorney work to act as a trustee of a revocable living trust?
Does a power of attorney act?
Work to act as a trustee of a revocable living trust.
Those are two separate positions. So
Mhm.
the trustee is in charge of the trust funds and the revocable trust, and the power of attorney manages the assets of the person they are attorney in fact for that are not in the trust,
Okay.
if that person is incapacitated.
Okay, thank you. And then this a little more specific. Can you provide more context on cars? Do they go through probate, or is there another way to transfer cars?
So if a person dies with one vehicle and it's a husband and wife, a spouse dies, the spouse that's alive just transfers the motor vehicle by going to the registry of motor vehicles. They're allowed to do that. If a father or a mother or anyone else died and didn't have a spouse and it's going to be transferred, that would be part of their estate. And it would have to be probated and then transferred to somebody.
Okay.
If the only way it doesn't go through probate is if it's a husband and a spouse, spouse to spouse.
Okay, I'm not sure of this, but maybe you guys know. Does our firm prepare M706 forms if needed?
Yes.
Yeah.
Great. That was an easy one. So just in general, what if a family doesn't go through the probate process? Could you give sort of what would that look like?
Well, I guess in an ideal scenario, maybe they had a trust and also all their assets had beneficiaries on them. So that's a scenario where probate would be avoided because assets are either held in trust, like real estate can be put into a revocable living trust during your life, and you would avoid probate on the real estate by it being in trust. And then if you had other retirement policies, or you put your bank accounts to have either in the trust or named a beneficiary on those accounts, that would avoid probate altogether because you're avoiding probate with the assets in the trust, and then you're avoiding it by making sure there's a beneficiary on all of your accounts and policies.
Okay, and then when do you recommend drafting a trust to avoid probate? I think I know the answer to this one.
When do we recommend it?
Yeah, all the time.
I guess usually, yeah.
Yeah.
It's a good idea, especially as we've discussed with when there's real estate involved, because as soon as it's owned by only one person, you can put it in trust, or you could add a life estate. I mean, there's different options, but it's a good idea to have a trust because putting your assets in your trust will make sure everything flows through at your passing through the trust without probate.
I learned something too. That one I knew. Okay, what about homes? What happens with a home while it goes through probate? Can you rent it out? Do you know?
You can rent it out, but it's not if the house is going to be sold, that would not be advisable. It would open it up to deterioration or claims, but sometimes family want to keep the house. So they're more than welcome to rent it out. The beneficiaries of the house could rent it out. That happens a lot when people have like a two-family, or they just don't want to sell. So as long as the beneficiaries all agree.
Okay. And I think that is it for now. So I want to say thank you to both of you. I always learn a lot when I get to listen to these as well. There's a lot to probate and when you're going to need it, clearly. So we recorded this. I know that this was a lot, so you can review it once it's available. If you haven't subscribed to our e-letter, that's a good way to always make sure you're up to date with all the information and news and events that we are sharing. And as well, under the resource section on our website, And then if you guys can just put up the contact page.
Oh,
Oop, there we go. So if you have follow-up information, there's both Abby and Maria's info. So please feel free to reach out. And I think with that, let's go enjoy the beautiful sunny day. All right. Thank you so much.
Thank you.
Thank you.